Good morning. Good evening, everyone. Go ahead, sir. We're on live. Okay. Live on YouTube live. That's it. Good evening to all of you. We were just discussing Order 21, that's the procedure for execution. As far as the stages of the suit is concerned, it is first filing of a document into the court by a person who approaches the court called the plaintiff. And then after that, the second stage is summons are issued to the opposite side under Order 5. Then the third one is Order 3, Order 4 speaks about appearance of the parties. And then we go to Order 8, that is filing of written statement by the defendant. And after that, issues are framed under Order 14. Then after that, the next stage is examination of witnesses, that is order 16 and 18. Then ultimately, judgment and decree, that is Order 20. But the litigation which you have initiated in a civil court, the methodology through which you reap the fruits of the decree is what is called execution. Execution has got a different connotation as far as civil law is concerned. It means where you file an application before the court, sir, I have obtained this decree. Please permit me to execute the decree by recovering whatever I have to get as far as the relief is concerned. Here, Order 21 comprises of 110 rules. Don't be dismayed by the number of rules in Order 21. An advocate who is familiar and perfect with Order 21 can be a successful advocate on the civil side. Here, Order 21, Rule 1 speaks about the modes of payment. How Rule 1 says how the payment due under the decree has to be paid. As far as the decree is concerned, the judgment debtor or the person who has suffered a decree can deposit that money into the court towards the satisfaction of the decree, and then notice will be issued to the decree holder saying that these are the amounts which are deposited. Or straight away without approaching the court, the judgment debtor can pay the money, whatever is the principal, interest, and cost of the suit can be paid directly to the decree holder. That is what Rule 1 says. Then Rule 2 speaks about payment out of court. Please remember, every decree holder will welcome this. Instead of depositing the money into court, the judgment debtor can directly make the payment to the decree holder outside court and then file a memo into the court, sir. The entire amount has been paid. This is how it has been paid. Then the court records what is called full satisfaction. Then there are two things. One is what is called court executing the decree, and court which passed the decree and court which executes the decree. What do you mean by that? Here, Rule 3 says, uh, suppose the property, two or more properties are located in two or more places. Then it is said, uh, any one of the courts, you can always file an application even to attach the property in execution as far as the court which passed the decree. Then Rule 4 says, sometimes what happens is when it goes below the figure of 2000 rupees, the civil court will not entertain the matter but transfers the matter to the small cause courts wherever it is located. As far as twin cities are concerned or metros are concerned, we have got small cause courts, but it will be transferred to a sub court or the junior court as the case may be. That is what Rule 4 says. Then mode of transfer, court can send for execution. Sometimes what happens is the decree is already passed, the judgment debtor goes outside the jurisdiction of the court. Then in that particular case, what the court can do is it can transfer the decree to the court where the JDR or the judgment debtor resides. Then what is the procedure to be followed? That is Rule 6. It says whenever an application is made for transfer of the decree or the court wants to transfer it, the copy of the decree and certificate of non-satisfaction and a copy of the order transferring the execution petition for enforcement to another court for execution will have to be transmitted to the court where the EP has been transferred. Let us take an example. Suppose, let us say, at the time of decree, the judgment debtor was residing at Hyderabad. Then, let us say, he goes and transfer to Nalgonda. Then, in that case, the court can send it on application made by the decree holder. The court can transfer the decree to the courts at Nalgonda and ask the Nalgonda court to execute the decree. What are the papers which have to be sent for? The copy of the decree, copy of the order for transfer, and then certificate of non-satisfaction to say that the decree has not been satisfied. Please execute the decree on our behalf. Then Rule 7 is copies can be filed in proof execution of decree by court to which sent. Please remember, you can always file, if suppose the decree is transferred to another court for execution, it is free for you to file a fresh EP, or in the same EP you can file all the papers stated above. Then decree another court, and then next one is Rule 10. Yesterday I was discussing, that is application for execution has to be made, and under the civil rules of practice it is form number 7. That is as far as execution petition is concerned. Here, whenever you file an execution petition, what are the papers you are supposed to file? Number one, the execution petition in the printed form or the format. And second one is you have to file the copy of the decree, and also you have to file what is called an affidavit saying that no appeal has been filed against the judgment and decree of the court, and that the decree is not satisfied, and there is no stay passed by the appellate court, and there is no bar for executing the decree. One thing is said, that as far as the decree which is less than 2 years, no notice is necessary for the judgment debtor. But the High Court circulars have said, since frauds are played in most of the cases, notice is absolutely mandatory. You will have to pay the process, or you will have to pay the BATA for notice why execution should not issue to the judgment debtor. And once the notice goes to the judgment debtor, the judgment debtor has got a right of filing a counter and opposing your execution petition. And then what we yesterday discussed also was what are the contents of an execution petition. First is name of the court, then execution petition number, or what is they call it as EP number of whichever year it may be, in what suit the EP has been filed, in OS number so and so so and so, Then the name of the decree holder and name of the judgment debtor or judgment debtors or decree holders. Then what are the columns which are there in execution petition? First is number of the suit. First one is number of the suit. Second one is name, address, and description of the decree holder or decree holders. Third one is name, address, and description of the judgment debtor or the judgment debtors. Then after that, amount of decree, then interest awarded from what date to what date and what amount. And then after that, you go to what is called interest from the date of decree till the date of filing the execution petition. Then after that, whether any EP filed earlier, that you have to say and give the number and result. And next column is whether any appeal has been filed against the judgment and decree of the court. That also you have to mention in which suit it has been filed, where it has been filed, so on and so forth. Then after that, you say amount of cost awarded. What are the costs? What is the cost awarded by the lower court? Then you come to the total. Then after that, you come to against whom you want to execute it. Again, you want to execute it against JD number 1 or JD number 2 or JD number 3, whatever may be the case. Then the last one is relief claim to issue a warrant of attachment of salary under Order 21, Rule 48, CPC against the judgment debtor number 1, judgment debtor number 2, and judgment debtor number 3. And then if you go to the back side, then you say in the schedule, you mention what is the salary of the judgment debtor, then what is the amount that is exempted, and what is the amount that is attachable. Then you say what is the claim you have got, to what extent you want the attachment to be made. Then, like a plain, the execution, but the schedule is verified and signed by the decree holder, and you as an advocate, you also sign the execution petition as the counsel for decree holder. Then you got the docket which you have to do it. This is how the contents of an execution petition lies. Then you are also supposed to file what is called an affidavit or what is called no stay affidavit. You state all the facts and say this has been decreed on so and so. The time limit for filing an appeal is so and so time. No appeal has been filed. The judgment and decree has become final, and no stay has been issued by any court till this date, and there is no harm in executing the decree. Please permit me to execute the decree. That is what is called no stay affidavit. Then, along with the execution petition, again I repeat, copy of the decree has to be filed, and copy of what is called non. And then you give a statement saying that what is the decree, what is the amount awarded, then what is the cost, what is the interest, so on and so forth, by way of a memo. And on receiving the application, the court, if it finds that all formalities have been complied with, then numbers the application as an execution petition or what is called EP. Then the next step is notice is issued to the judgment debtor to show cause why execution should not issue. Then in that particular case, the judgment debtor is given an opportunity of filing his counter and also opposing the application. And after arguments are heard on both sides, the court passes the order as far as the execution petition is concerned. This is what all we have done yesterday. Then sometimes what happens is in order 21 rule 11 it said whenever it's a money decree at the time of passing the decree, the court can order arrest of the judgment debtor. Here it is said under rule 11, where a money decree is passed and the court, without waiting for the execution petition itself, can straightaway order for arrest of the judgment debtor and to put him in civil prison. Then Rule 12 says that a written application is necessary. I gave you the format also. Then after that, suppose the judgment debtor is not in possession of the property, then the decree holder can ask for inventory. It can state the properties owned by the JDR and what are the movable properties and in whose possession it is by filing an inventory into the court. Then we go to I think this is what all we have done yesterday. I was also dealing with what is called application for simultaneous execution. What do you mean by application for simultaneous execution? As per rules, you can ask only for one relief. But in the same execution petition, you can ask for two reliefs. You can ask for attachment of salary, or you can also ask for attachment of mobile property and sale of mobile property. Then, in that particular case, you'll have to file an application before the court, what is called an execution application, and ask the court to give you permission to take simultaneous execution, ask for two reliefs, and then in appropriate cases, the court, after hearing the counsel for the decree holder, passes an order saying, sir, you can also proceed for attachment of salary and also attachment and sale of mobile property. And that is what is called under Order 21, Rule 21. You can ask for simultaneous execution. Then, here, Rule 13, that is, Rule 12 speaks about attachment of mobile property not in possession of the JDR. DH can annex an inventory of the property. Sometimes what happens is the property, mobile property, which you want to attach is not in possession of the JDR or the judgment debtor. It is in possession of his brother or it is in possession of his wife. Then in that case, according to your knowledge, whatever mobile property is there, you file an annexure showing the mobile property and give its value thereof. That is what Rule 12 says. Then Rule 13 says application for attachment of immobile property. What do you exactly mean by attachment, sir? Attachment is something like a prohibitory order whereby the other side is restrained from alienating the property that is mentioned for attachment. Here, what is the effect of attachment? Effect of attachment is there is a prohibitory order directing the JDR not to transfer the property, or there is a charge on the immobile property where it is subject to the suit concerned. మీరు ఆయనతో మాట్లాడి పంపించండి. So, as far as attachment is concerned, it is something like a prohibitory order whereby the. Please pause for 5 minutes. बात करिए कल्याण साहब. Yeah, file తీసుకురండి. Tomorrow we'll finalize it. Let us file it also. Court has directed him to file a separate OP. No problem. That amended plaint is already there. कल आ जाइए. Here. Sorry, please. Here, as far as mobile property is concerned, if it is not in possession of the judgment debtor, the decree holder can annex an inventory of the property. What do you mean by inventory? Inventory means what are the lists of immobile property not in possession of the judgment debtor, but the judgment debtor has got a saleable interest as far as the mobile property is concerned. Then in that particular case, the inventory can be filed into the court and the necessary procedure can be adopted. Then the Rule 13 speaks about attachment of immobile property. What do you mean by an attachment of immobile property? That means here the immobile property which is owned and possessed by the judgment debtor becomes liable to satisfy the debt due and payable to the decree holder. And first and foremost is that property will be attached. That means the judgment debtor cannot alienate the property or encumber the property without the permission of the court. It is subject to the charge of the court as far as that particular suit is concerned. Then, as far how an attachment is made, sir, the bailiff attached to the Nazaret or the Amina, as it is called, goes to the spot and then says, then says that this property is attached in EP number so and so, in OS number so and so. No person should purchase the property. It's subject to a charge for the money due and payable to the decree holder. Suppose it's a village. What they do is they affix it on any conspicuous part of the village and also affix it on the notice board of the MRO or the Tahsildar as the case may be. And also, Tom also takes place that this property is under attachment. And preferably, they also put a notice saying that this property is subject to attachment in so and so. people are cautioned not to purchase this property. That is what is called how attachment is affected. Once attachment is affected, that immovable property cannot be sold, cannot be alienated, cannot be encumbered. It's subject to the charge of the decree holder as far as his money is concerned. That is what Rule 13 says. Then I'll discuss this in detail when I come to the sections as far as what is the procedure to be followed as far as execution is concerned when it concerns immovable property. The corresponding section is section 54 of CPC, and again you have got the other sections also, how proclamation is made, how the property is sold and all. When we come to that, when we come to the sections, I'll discuss about that. Then we go to Rule 15. Sometimes what happens is there are joint decree holders. Joint decree holders means more than one decree holder. Then in that particular case, unless the decree specifies that only this decree holder alone can proceed, the question is one decree holder can proceed, can file an execution petition for and on behalf of the other decree holders. Also, absolutely, there is no bar unless the court imposes conditions or restrictions. Rule 15 says one of the decree holders can always file an execution petition. Then we go to Rule 16, application for execution by transferee of decree. I told you a decree also can be assigned. If you come to this, I think most of you are advocates know, most of the people hover around courts and say they are interested in purchasing litigation oriented properties. Suppose the property, when sold in the market, it can fetch about 40 lakhs. They'll purchase it for 20 lakhs and they take an assignment deed and say that all the rights of the decree holder is purchased by them or it is assigned to them, and they can execute the decree for and on behalf of that decree holder. And that assignment deed is filed into the court, and what the assignee does is he wants that to be recognized, and also he can transfer, he can execute the decree provided notice is given to the assigner and notice is given to the judgment debtor as far as the assignment is concerned. Then uh, here, Rule 17 says once an execution petition has been filed into the court, what is the procedure to be followed by the court? What the court has to do is the Sharastadar or the CMO or the superintendent of that particular court has to check the application and then find it out whether it is in order, whether all the formalities laid down in Rule 11 to Rule 14 have been complied with. And once it is complied with, it is numbered as it is placed before the presiding officer. The presiding officer directs the section to number it as an EP and issue notice to the judgment debtor. That is the procedure followed in Rule 17 of Civil Procedure Code. Madam, CPC. CPC. Here, Rule 18 discusses about execution in case of cross decrees. There it is said where I'll give an illustration and then come to the section order, please. Here, where A holds a decree against B for 1,000, B holds a decree against A for the payment of 1,000. In case A fails to deliver certain goods at a future date, B cannot treat his decree as a cross decree. Under this rule, A and B co-plaintiffs obtain a decree for 1,000 against C, and C obtains a decree for 1,000 against B. C cannot treat his decree as a cross decree. What do you mean by cross decree? Where the parties are same, and in respect of that, plaintiff is the same, defendant is the same. Plaintiff has obtained a decree against the defendant, and defendant in another suit has obtained a decree against the plaintiff. Then, in that case, they are called cross decrees. In this particular case, for the execution of in separate suits for the payment of past between the same parties capable of execution, If two sums are equal, satisfaction shall be entered upon both decrees. Suppose, let us say, plaintiff has obtained a decree for 10,000 rupees against the defendant. Defendant in another suit against the plaintiff has obtained a decree for 10,000. Then here both the sums are equal. Then instead of having separate execution petitions, the court can record satisfaction and adjustment and say the claim of the plaintiff is satisfied, the claim of the defendant is also satisfied. What is called a cross decree is between the same parties when the plaintiff obtains a decree against the defendant and the defendant in another suit obtains a decree against the plaintiff and the sums which are decreed are almost identical, then in that particular case, the court can record satisfaction instead of proceeding with execution. This is what is called cross decrees. Then second one is if the two sums are unequal, execution may be taken only not taken out only by the holder of the decree for a larger sum and for such much only as remains after deducting the smaller sum, and the satisfaction for the smaller sum shall be entered on the decree for the larger sum as well as satisfaction on the decree for the smaller sum. Here, let us say plaintiff has filed a suit against the defendant for recovery of 2 lakhs. The defendant has filed a suit against the plaintiff for recovery of 1 lakh. Then what? Here the amounts are not equal. Amounts, if they are equal, satisfaction can be recorded. Absolutely, there is no problem. If the amounts are not equal, they are unequal, then the largest sum is taken for execution, and out of the largest sum, the smaller sum which is due and payable will be deducted, and the decree will be executed only regarding the balance of the amount. First and foremost is if the sums are equal in both the decrees, satisfaction will be recorded. If the sums are unequal, then the larger decree is taken into consideration and the smaller amount which is due and payable is deducted from that, and the decree will be executed only to the extent of the balance of the money which is due and payable after adjustment. Here again I repeat, here that is execution in case of cross decrees. What do you mean by execution in case of cross decrees? A has filed, I'll take an example. A has filed a suit against B for recovery of 10 lakhs. And A is also indebted to B to the extent of 10 lakhs. A has obtained a decree, B has obtained a decree. Then what is the situation? Both the sums are equal. Are you able to follow, please? Then when both the sums are equal, in the same suit, the satisfaction can be recorded and the matters can be closed once and for all. Are you able to understand, please? Second one is in a cross decree. Suppose A has obtained a decree against B and B has obtained a decree against A. A has obtained a decree for 20 lakhs. B has obtained a decree against A for 10 lakhs. Then if the sums are unequal, the larger amount is taken into consideration. From that, this 10 lakhs, what B has to get from A, will be deducted and then satisfaction will be recorded. So execution can proceed only against 10 lakhs. Are you able to understand, please? A has filed a suit against B, obtained a decree for, let us say, 20 lakhs. And B has filed a suit against A and obtained a decree for 20 lakhs. Then in that case, if both the sums are equal in the decree, satisfaction will be recorded. The second limb of this rule is that if the sums are unequal, the larger amount is taken into consideration. The smaller amount which is due by the same plaintiff to the defendant in another decree, that will be deducted, and then the balance alone the plaintiff will be entitled to recover. Are you able to understand, please? If sums are equal, satisfaction is recorded. If sums are unequal, then in that particular case, the higher amount is taken, higher amount of the decree is taken, the lower amount will be deducted from out of the higher amount, and the indebtedness will be found after deducting it, and the plaintiff can recover only the amount which has been arrived at after deduction of the smaller amount. These are the two limbs of Rule 17. Are you able to follow, please? Please caution me if I'm going a bit fast, please. Here, when does this rule apply, sir? When the parties fill in the same character. When A files a suit against B, A is the plaintiff and B is the defendant. Am I making myself clear to you, please? And in another suit, B is the plaintiff and A is the defendant. Then who is the decree holder in the first suit? A is the decree holder and B is the judgment debtor. Am I making myself clear to you, please? In the second suit, B is the decree holder and A is the judgment debtor. Here, party should fill up in the same character. Plaintiff should be the same and defendant should be the same. Decree holder in the one suit should be the same and the judgment debtor should be the same. In another suit, the decree holder becomes the JDR and the decree holder in the earlier suit becomes the. So they must fill in the same character. Unless they fill in the same character, cross decrees cannot be executed. Any questions, please? Please try to clarify your doubt, please. Again, I repeat, because please remember, I'm going to go at a very small pace, a small snail pace, as far as 21 is concerned. Rule 17 says, if two cross decrees are passed and A files a suit against B for recovery of 20 lakhs, A files a suit against B for 20 lakhs and B files a suit against A for 20 lakhs, then if the sums are equal, satisfaction will be recorded, EP will not be proceeded against. Are you able to understand, please? If the sums are unequal, the larger amount which has been decreed will be taken into consideration. The smaller amount which the JDR has to get from the decree holder in this suit will be deducted from the larger amount and the sum determined, and the JDR will be asked to pay only that amount which is due and payable. The second thing is this provision applies only when parties occupy the same character. In a suit filed by A is the plaintiff, B is the defendant. In a suit filed by B is the plaintiff, A is the defendant. And amounts are claimed against each other. They filed cross suits. In cross suits, two decrees are passed. In one case, A is the decree holder and B is the judgment debtor. In another case, B is the decree holder and A is the judgment debtor. They occupy the same character and same transactions. Then, in that particular case, this particular provision applies. Am I making myself clear to you, please? Here, one thing is this. I'll take an example, sir. A and B co-plaintiffs obtain a decree for 1,000 against C, and C obtains a decree for 1,000 against B. C cannot treat his decree as a cross decree under this rule. Please remember, parties should fill in the same character. Here, A and B are the plaintiffs. That means A and B are the persons who have gone to the court, and they obtain a decree for 1,000 against C. Then C files a suit and takes a decree only against B, not against A. Then in that case, can you call it a cross decree? Execution for cross decree? No. Why? Because here the parties are not the same. In one case, A and B filed the suit against C, obtain a decree. Another suit, C files a suit only against A, only against B, and obtains a decree. A is absent there. When A is not there, the question of it cannot be called a cross decree. Am I making myself clear to you, please? I again repeat this illustration. A and B file a suit, a co-plaintiff file a suit against C and obtain a decree for payment of 1,000 rupees. Then C files another suit, obtains a decree only against B for a particular sum of money. It cannot be called a cross decree, so this rule does not apply. Why? Because A is absent in C's suit. Only it is the decree is obtained only against B, not against A. So, in case cross decrees have to apply and this rule has to apply, parties should fill the same character. One should be one in one case, earlier case, if A is the decree holder and B is the judgment debtor. In another case, B should be the decree holder and A should be the judgment debtor. Here, one other person has come. You have obtained a decree against that particular person, not against me. Then in that case, it cannot be called a cross decree, and this rule 17 does not apply. Here, rule 8, rule 19, rule 19 speaks about execution in case of cross claims under same decree. where application is made for the execution of a decree under which two parties are entitled to recover sums of money from each other. If two sums are equal, satisfaction shall be entered. If they are unequal, they may be taken out only by the party entitled to a larger sum. Sometimes what happens is in a single suit, when I discuss counterclaim, the parties occupy the same character. That is, plaintiff files a suit for recovery of money against the defendant, and the defendant has to get some money from the plaintiff, and he files what is called a counterclaim, or he files a suit for counterclaim, saying, "Sir, I have to get more money from the plaintiff, though he has filed a suit for 10 lakhs, I have to get 15 lakhs." Instead of B being driven to another suit, B can file what is called counterclaim and claim that 15 lakhs which is due and payable to him, and also say that 10 lakhs which is due and payable to the plaintiff can be set off. This 5 lakhs, this out of 15 lakhs, 10 lakhs can be set off, and 5 lakhs I'm entitled to it. That is what is called a cross claim or a counter claim made by the defendant. But what are the essentials of that, sir? The plaintiff should be the same, defendant should be the same. And sometimes it so happens in the same transaction, the plaintiff is due some amounts to the defendant. Instead of the defendant going to another suit, he can ask for counterclaim under the provisions of Order 8 and say, "Sir, I have to recover 15 lakhs from the plaintiff, and no doubt 10 lakhs the plaintiff is claiming. I am liable, out of this, plaintiff is liable to pay me 5 lakhs. Instead of the defendant going for another suit, in the same suit, he can ask for his counterclaim to be adjudicated. Then, in that particular case, if the court on inquiry finds that the defendant has to get 15 lakhs and the plaintiff has to get 10 lakhs, then in that case, 10 lakhs will be deducted out of that 15 lakhs, and the defendant will be entitled to recover that excess of 5 lakhs from the plaintiff. This is what is called a counterclaim. If the sums are equal, let us say plaintiff has filed a suit for 10 lakhs, defendant has filed another suit for 10 lakhs, and both the sums are equal, then they can be offset against each other. But if the sums are unequal, then in that particular case, the larger amount is taken. From that, the smaller amount is deducted, and the rest of the balance, whatever is the balance, alone you can proceed in execution. That is what Rule 19 says. Yeah. As far as Rule 21 is concerned, I've already discussed. That is to say, simultaneous execution. Simultaneous execution means where you can ask for more than one relief. That is where the decree holder is the same, JDR is the same. Then in that particular case, you can ask the court, "Sir, please permit by way of filing an execution application," not IA. It's called EA. EA means execution application in the same execution petition, and saying, "Sir, let me proceed against both the attachment of salary as far as and attachment of attachment and sale of mobile property. In all appropriate cases where the court is satisfied about the application made by you, court permits you to proceed not only against the attachment of salary but also against the attachment and sale of mobile property or immobile property, as the case may be." So, one thing you must remember is simultaneous execution cannot be resorted to without filing an application under Order 21, Rule 21, which speaks about simultaneous execution. Then, suppose an execution petition is filed, you want it to be stayed or you want it to be kept in suspended animation till such time the appeal before the appellate court is heard and disposed of, then most of you file it under 151. Please remember, in an execution petition which is already filed, if you want to ask for stay, the correct provision is Order 21, Rule 26. Order 21, Rule 26 is stay of execution pending disposal of the appeal. That is Order 21, Rule 26. Then, in all appropriate cases, when you ask for stay, you cannot get a blanket stay unless you deposit the decretal cost into the court or furnish security for the at least 50% of the amount claimed by the plaintiff and awarded by the decree. That is what Order 21, Rule 26 speaks about. Yesterday, I was also discussing about the modes of execution. Modes of execution is you have got five modes of execution. One is what is called, again, kindly make a note please. Attachment of salary. Number two, attachment and sale of movable property. Third one is attachment and sale of immovable property. Fourth is arrest and detention in civil prison. And fifth one is appointment of receiver to collect the rents and share of profits and so on and so forth. Yesterday, when I discussed attachment of salary, it is subject to Section 60 of the Civil Procedure Code. As far as the old code is concerned, 1908 code is concerned, it was said whenever attachment of salary is sought, first 400 rupees was exempted, and above 400, two-thirds was exempted, and what was attachable is only one-third of the salary of the JDR. But in 1976, when the cost of living had gone up, then in that case, the Section 60 was amended, whereby they say first 1,000 is exempted, above 1,000 two-thirds is exempted, and above two-thirds, only one-third can be attached. That is what Section 60, as it now stands, after the amendment in 1976 by Act 46 of 1976, it says first 1,000 is exempted, above 1,000, two-thirds is exempted, and after two-thirds, only one-third can be attached. Then, of course, the question arises, sir, whether it's net salary or gross salary. What do you mean by gross salary? Gross salary means including all your allowances, perquisites, whatever you get is called the gross salary. But that is what then net salary. What do you mean by net salary, sir? Whatever is deducted from your salary, like for towards PF contribution, gratuity contribution, or any other contribution, or any loans, etc., then they are, that has to be taken into consideration in order to determine the net salary of an individual. And sometimes what happens is the salary itself sometimes is attached by many creditors because you're so, I mean, you're due and payable so much of amount to others, but of course you don't mention it how much. So first 1,000 is exempted, above 1,000 two-thirds is exempted, and after two-thirds only one-third becomes attachable. Then what is the procedure followed? This is under Order 21, Rule 48. Order 21, Rule 48 CPC. Then in that particular case, what happens is once attachment is sought, the court issues a warrant to the disbursing officer. Whenever the salary of the individual is likely to be paid, please deduct this amount from out of his salary and then remit the amount to the credit of the OS or the suit or the execution petition regularly till the entire debt is completely satisfied. And once the warrant is received by the disbursing officer, it is a duty of the disbursing officer before payment of the salary to deduct that amount and then send a check or a draft to the credit of the court, to the credit of that particular suit or execution petition, and that amount is credited towards part satisfaction of the decree. That's the procedure that is followed. Then, in case, let us say, the disbursing officer does not deduct the money but pays the entire salary, he is liable for disobedience, and the court can issue a warrant also to asking him to show cause why his action should not be taken against him. Normally, when warrant is served on the disbursing officer, it is a duty of the disbursing officer before payment of salary to deduct the amount that has been ordered by the court by way of attachment and then remit that amount periodically to the credit of the suit or credit of the execution petition, as the case may be. That is what we discussed yesterday. But Section 60 lays down various provisions which says that what are the properties that cannot be attached. I gave you the first example, 1,000, above 1,000, two-thirds. Above two-thirds, one-third alone becomes liable for attachment. Second one is wearing apparel of people. See, after all, we do not want to expose our body. I have got only one shirt, one bunion, one undergarment, and other things. You cannot attach it. I can't go nude into the bazaar. So the wearing apparel, what you use for your daily use, that cannot be attached. Then third one is agricultural income. Please remember the bane in this country is agricultural income is not taxed to income tax. I think most of you know about it also. that is agricultural income, and dwelling house of an agriculturist. Then the income of a small farmer and the house owned and possessed by him in the village. But in Pakistan, please bear it in mind, agricultural income is taxed. But in India, even today, agricultural income is not taxed. But indirectly, they collect the tax by introducing what is called levy. Out of the total produce, you are supposed to surrender a certain percentage to the government by way of levy, and it will be taken to the FCI go down and then distributed to the poor or distributed at the times of need. But here, as far first one is salary, I've already discussed. Second one is tools of artisans. What do you mean by tools of artisans? You find small people sitting on the road, mochi as they call it, cobbler, or then let us say lathe machine persons. And these people are all artisans who do their job on piecework. Then their tools cannot be attached. Then fourth one is that stipends are allowances which are paid to persons belonging to the army, navy, and air force that cannot be attached. Then the provident fund of the employee also cannot be attached. Gratuity also cannot be attached. Then these are all the various things which are provided in the section 60. There is a bar as far as execution is concerned. This is what all we did yesterday. The second one I discussed was the attachment and sale of mobile property. Whenever an attachment for sale of mobile property is sought, it is sought under Rule 43 of Order 21. And you ask for, you give in the schedule, you say in the relief column, especially in the execution petition, you say to issue a warrant of attachment and sale of mobile property under Order 21, Rule 43 CPC against belonging to the JDR or the judgment debtor. And behind it, and the reverse, you have the schedule. You say for 10 chairs, 10 tables, 10 computers, then a fridge, then television set, so on and so forth. And you give the value of that also. And you also say that other mobile property that be pointed out at the spot, and you give the value of that, and you say to what extent you are claiming attachment and to the extent of your decretal amount with cost. Then the execution petition is verified, and then the party signs and files into the court. Then the procedure is, once the execution petition is filed, normally if the decree is within 2 years, no notice is necessary. But according to the High Court circular, High Court circular, it is mandatory that notice has to go to the JDR, and JDR will be given an opportunity. JDR means judgment debtor who has suffered a decree, and he will be called upon to explain why the property should not be attached or why it should not be sold in execution. Then in that case, how the attachment is proceeded is the warrant is sent to the bailiff of the bailiff attached to the Nazaret. Bailiff goes to the spot and serves the attachment notice to the judgment debtor. And if the judgment debtor refuses to take the notice, it is affixed on the door. And if it's a village, it is affixed on the conspicuous part of the village. And a copy of the notice, the warrant is also affixed on the notice board of the Tahsildar or the Revenue Department or the sub-registrar also, that this property is subject to attachment. In this particular case, no person should purchase that property. Then how long the attachment will survive? The attachment will survive till such time the judgment debtor pays the money, whatever is due and payable towards the decree. And once that amount is paid to the court or paid to the decree holder directly, full satisfaction will be recorded and the attachment will be raised. Then suppose, let us say, take the other way around. Suppose even after attachment, the money is not paid. Then in that particular case, the decree holder can apply to the court, sir, please bring the articles to the court and I'll give after wide publicity and in the auction conducted in the court premises by the Nazaret or by the bailiff, the highest bidder gets the article, and that amount which is realized from out of the sale will be credited to the credit of the suit or the execution petition. This is the procedure that is followed as far as attachment and sale of mobile property is concerned. This is what all I've done yesterday. Any questions, please? Then we go to the third one also, which I discussed yesterday, was Order 21, Rule 37 and 38, CPC. Here, where the judgment debtor even after having a saleable interest over and properties, avoids and evades payment of the decretal amount to the decree holder, the decree holder can apply to the court to arrest and detain the judgment debtor in civil prison towards satisfaction of the decree. Then what the court does is it issues notice to the judgment debtor, asks him to show cause why you should not be arrested. Then the judgment debtor appears before the court and then files his counter and also goes into the witness box. He is examined and cross examined. And after that, if the court is satisfied that this man has got means but he is not paying the debt, then in that case, he will be arrested and put in prison. And the maximum period for a person can be arrested and kept in civil prison is 3 months in 1 year. If you take an arrest in 1 year and you take a imprisonment is ordered for 3 months in that year, you cannot arrest him again. Only the next year you can proceed for the same relief. But this has been negated by the leading judgment of the Supreme Court reported in AER 1980 Supreme Court 470, a famous case of R.C. Varghese versus Bank of Cochin, where the legality of Order 21, Rule 37 and 38 was questioned before the Honorable Supreme Court by a judgment debtor. He said ordering this particular arrest and detention amounts to violation of his fundamental rights guaranteed to him under Article 14, that is equality before law and equal protection before law, and Article 21 and 22, that is rights of personal liberty. This case came up before Justice V.R. Krishna Iyer, who I quote Justice Krishna Iyer as follows: that is, to hold the person of the judgment debtor as an hostage of the court, to hold the person of a judgment debtor as an hostage of the court is to satisfy the Machiavellian designs of a modern Shylock, that is the decree holder who wants to deprive the judgment debtor of his personal liability. And this case even went further by saying, sir, even though the sons and daughters have got properties, they are in a position to liquidate the debt, they are in a position to pay back the debt. What has to be seen under Order 21, Rule 37 is only the means of the judgment debtor has to be taken. His family members' means need not be taken into consideration. That's what His Lordship Justice V.R. Krishna Iyer observed in the famous case of R.C. Varghese versus Bank of Cochin. I think this is what all I've done yesterday. I'm repeating for the benefit of all of you, some of you who were not present yesterday, so that it will be a sort of revision for you. Then I said, if you want to take a stay in execution, it is not section 151, please. It is Order 21, Rule 26, where for reasons mentioned, you can ask for stay and say that it should be kept in suspended animation till some other matter is heard and disposed of according to law. That is what Order 21, Rule 26 says. Then we have got appointment of receivers. And then we go to attachment and sale of immovable property. How attachment and sale of immovable property takes place is, once an execution petition is filed, the description of the property, the location of the property, the extent of the property, where the location of where it is located, and then you ask for that property belonging, owned and possessed by the judgment debtor to be attached. That is, the prohibitory order is issued, whereby the JDR is restrained or compelled not to sell the property or encumber the property till the payment of the debt. That is what is called an attachment. Attachment means a prohibitory order not to sell the property. Attach the property means say that this is subject to the rights of the decree holder to recover his debts through that execution petition. Of course, how attachment is done under the provisions of Order 21. Order 21, please. Here, under Section 54 also, Order 21, Rule 54, read with Section 54 of Civil Procedure Code, provides for attachment and sale of immovable property. Of course, there is a particular procedure followed for that. when I come to sections, whenever what are the papers to be filed in such a contingency, we will discuss it when we come to proclamation of sale in the sections part of it. Then after that, we have got receiver. What do you mean by receiver? Receiver is a person, something like an administrator, who is an officer of the court, who is in the panel of receivers, kept in the panel and maintained by the court. He, whenever any property, the judgment debtor is receiving the rents, receiving the profits, but he is not paying the decree holder, then the decree holder can ask the court to appoint an administrator or to appoint a receiver to collect the rents, income arising out of the property, and then credit it to the suit regarding the amount whatever is due and payable to the decree holder. Of course, this is a very uh, what is called rare remedy. So these are the five modes of execution that is provided under Order 21. Then we go to how a decree for specific performance and injunction is executed or is executed. That is the correct provision for that is Order 21, Rule 32. Order 21, Rule 32. That is, whenever you obtain a decree for injunction or whenever you obtain a decree for specific performance, it can be executed under the provisions of Order 21, Rule 32. That means, suppose, let us say you obtain a decree to direct the opposite side to execute a sale deed, which it does not do so, then through the filing an execution petition under Order 21 Rule 32 before the court, you can ask the court to direct the defendant or the JDR to execute the sale deed and in default to appoint an advocate for the court itself to execute the document for and on behalf of the judgment debtor. That is as far as specific performance suit is concerned. Then injunction suit. Suppose you obtain a decree for injunction. What do you mean by injunction? I'll come to it later. Here, as far as injunction is concerned, you succeed in obtaining a prohibitory order from the court, and if it is disobeyed, no doubt you have got provisions of Order 39, Rule 2A, where you can make the other person liable for contempt or disobedience. But that decree also can be executed under Order 21, Rule 32. And even a decree for restitution of conjugal rights granted under the HM Act or the Hindu Marriage Act or the Special Marriage Act or the Muslim Marriage Act or whatever it is can be executed under Order 21 Rule 32. The leading case on that aspect is Sarita versus Venkat Subbaya. That is the film actor Sarita and Venkat Subbaya were Esther husband, that is first husband. Then she questioned the wires of Section 9 of the Hindu Marriage Act, that is, as far as restitution of conjugal rights is concerned. And then it came up for one of the learned judges of our High Court, Justice P.A. Chowdhury. And while deciding that particular case in the writ petition, the High Court held that Section 9 is unconstitutional. You cannot compel any person to go and stay with her husband, which is very much against our wishes. But unfortunately, what happened was it opened the doors as far as wives to desert their husbands. And if you see the film land, most of the wives desert their husband and marry a second time. The Sarita's case was an encouragement. Then the matter was taken up to the Supreme Court by Venkata Subbaya, questioning the judgment and decree, judgment passed by Justice P.A. Chowdhury in the writ petition filed by Sarita. The Supreme Court negated the judgment of Justice P.A. Chowdhury and said the plaudits and the pundits, as far as the Hindu Marriage Act is concerned, were interested to see the matrimonial life of a party being restored and kept in proper way, and there is nothing wrong or unconstitutional as far as Section 9 of the Hindu Marriage Act is concerned, and therefore they said that the judgment was reversed. What I'm trying to tell you, how it has got a connection here is, in English there is a saying, you can take the horse to the pond, but you can't make it drink. Suppose, let us say, the husband obtains a decree for restitution of conjugal rights, and let us say he wants to compel his wife to come and stay with him. Please remember, no doubt you can file it under Order 21, Rule 32, but how far they can lead a matrimonial life, how far they can live happily and perform their respective functions as husband and wife is concerned is a questionable matter. And court cannot monitor the conjugal life of a husband and wife. That is the reason it is easier said than done. And Order 21 Rule 32 though provides for execution of a decree for restitution of conjugal rights, but it's very, very difficult to implement it. I think with this we shall stop today and we'll devote to interaction, please. Please ask questions, and I just humbly request you not to have any crosstalk because it disturbs others. Yes, your interaction time starts. Please be a bit loud so that it's audible and so that I can understand and explain to you, please. And please give out your name before you ask the question. Yes, any questions, please?
Sir, conjugal rights new marriage act related the Sarita versus
Venkata Subbayya.
whether in pet marriage case.
Yes. That can be executed under Order 21 Rule 32. But the Supreme Court said there is nothing wrong in passing an order decree for restitution. But here Sarita's case was upheld by the High Court, our High Court. But the Supreme Court said there is nothing unconstitutional as far as Section 9 of the Hindu Marriage Act is concerned. That is the judgment, please. Then also said under Order 21 Rule Order 21 Order 21 Rule 32 is Rule 32 is concerned. Even a decree for specific performance can be enforced under Rule 32. Huh? Then Order 21 Rule 32 says that even a decree for specific performance can be enforced by filing an execution petition under Order 21 Rule 32 to direct the opposite side to execute the sale deed. And in case the other side does not do it, court has got the power to execute the sale deed under Rule 32. And even an injunction can be enforced to Order 21 Rule 32. ఎందుకు ఎక్కువ వస్తుంది ఎవరు దూరం ఉండాలా
Ravi garu.
Yes, please, Mr. Ravi.
Can you explain section 60 again?
Just be a bit loud, sir.
Sir, can you explain section 60?
Section 60 is what are the properties that cannot be attached in execution. Number one is salary till 1,000 rupees is exempted. Above 1,000, 2/3 is exempted. And what is attachable is only 1/3. That means that what is attachable is only the net salary and not the gross salary. That's the first one. Second one is stipends received by the Army, Navy, and Air Force people. 3. Stipends received by professionals in discharge of their duties. Fourth one is that agricultural income of a small farmer and the dwelling house of a small farmer and the agricultural implements of an agriculturist. Then, as far as tools of artisans also cannot be attached. These are the various items that cannot be attached under Section 60. Am I making myself clear to you, please?
Yes, thank you.
Right. Next, please.
Yes, Uday garu.
ఎవరు? Yes, please.
Sir, while talking about the Specific Performance Act,
Yes. It's no act, sir. It is specific performance as laid down in Specific Relief Act.
so we have received one specific order to perform like registration of the building with the registration.
Right.
But still, it is not penalty is also imposed on the builder.
Right.
But the order we received 1 year before,
Right.
almost 1 year.
Right.
Still, it was not performed. So,
Right.
what steps needs to be taken next?
The steps you have to take is you have to file an application, the execution petition under Order 21 Rule 32 to issue notice to the builder, whomsoever it may be, to execute the sale deed. In case he does not do it, then you can ask the court to execute the sale deed in your favor on behalf of the judgment debtor. That is, you will have to file an execution petition under Order 21 to 32.
We including that penalties also there.
That penalty also you can recover by asking for payment of that and like a recovery of money.
From the recovery of money.
Yeah.
So for that, do I need to do any attachment of his assets?
That you can do it in the same petition which you file, EP which you file, you can ask and file an application under Order 21 to 21 also to say that not only to execute the sale deed but also to pay the penalty due and pay which has been imposed by the court. That is, you must take the permission of the court under 21 and ask for simultaneous execution.
But if we don't have any information to attach, so what to do in that situation?
Information you'll have to make, your decree holder has to make inquiries to attach the whatever properties are owned and possessed by the JDR.
It is our responsibility.
The duty of the decree holder to do it. No JDR will disclose these are the properties, come and attach. You follow?
Thank you.
DSR గారు అడుగుతున్నారు శ్రీనివాస్ రెడ్డి ఫ్రమ్ విశాఖపట్నం. How long the validity of an attachment of immovable property once attached?
Once attached, till such time the payment is made, the attachment will be valid, which is to be extended from time to time. Normally it is 6 months. Attachment will be valid only for 6 months. After that, you have to get it extended.
BSR garu, are you cleared with your doubt? Like Samsung, please unmute your mic.
Yes, sir. My name is Archana from Kerala.
Yes.
So my doubt is regarding Rule 37, whether whose burner proof is whose holder, whether the JD or degree holder, to prove the means.
Means has to be
Rule
proved.
37.
Means has to be proved by the decree holder, not by the judgment debtor, please. Of course, the decree holder will move heaven and earth to find out the means of the judgment debtor and also the saleable interest which the judgment debtor is got in various properties. He has to make a roving inquiry and try to come to a conclusion. The plaintiff has to say, the decree holder has to satisfy the court. Only the judgment debtor will come and say, I don't have any means.
Is sir said he has to enter into the box.
Yes,
So that's why
DHR also has to enter the box and show the means.
so JD need not to enter
JD
into
has
the
to
box.
come. JD has to definitely come because of the judgment in the provisions of 3738 says the JDR has to show his means. But here I'll give you an example. Suppose, let us say, the execution petition has been filed and subsequent to the execution petition, the JDR obtains some property or in some property has got a saleable interest that he has got means, but he is definitely avoiding to pay the debt. In that case, arrest can be ordered. Only in exceptional cases, arrest can be ordered, not mechanically.
Thanks.
Welcome.
Like Praveet garu adugutunnam, can I attach a vehicle?
You can definitely attach a vehicle subject to hypothecation, but it's attachment in the sense not what mafias do. Attachment means you can take this is normally resorted to by people who finance purchase of vehicles. They have got a lien over the vehicle. They can take it, attach it in the sense, take the vehicle, keep them in their custody, give a 15 days notice to the other side saying, sir, you have not paid the money. In case you don't pay within 15 days, we will sell the vehicle. Attachment can be also done regarding vehicles also, but provided you'll have to find out whether any hire purchase is there. That's why prominently it is displayed on the auto or the car, hypothecated to State Bank of India or hypothecated to Indian Overseas Bank. That means the bank will have the first charge over that vehicle. Yes? Next, please.
Good evening, sir.
Good evening.
Sir, myself Jamuna Tiwari. Sir, may you explain Order 21 Rule 41?
Rule?
Order
21,
21
sir.
Rule 41.
Rule 51.
21.
31.
Rule 21. That is simultaneous
Rule
execution.
31, sir.
Rule 31 have not. Rule 31 have not come as.
Order 21 Rule 21, sir.
Rule 21 speaks about simultaneous execution. That is, normally you can only ask for one relief in an execution application, execution petition. But if you want to proceed for not only for the salary but also for attachment and sale of movable property, you file an execution application, what is called EA, before the court. Ask the court to permit you to proceed both against the attachment of salary as well as attachment and sale of movable property. And in all appropriate cases, the court can order that you can proceed against both. That is called simultaneous execution.
Thank you, sir.
Welcome.
Right, any more questions? Right, Venkat garu, unmute yourself. Venkat garu, unmute your mic.
Good evening, sir.
Good evening.
Sir, my question is regarding legal heads of the deceased JDR.
Yes.
Yeah, I have encountered one case in EP, sir.
Yeah.
EP has filed by a non-banking financial company,
Right.
against the JDR number 123.
Right.
Basing on the arbitration award,
Right.
passed somewhere in Chennai or somewhere else.
Right.
In that, sir, the arbitration award was passed against the borrower and the guarantors.
Right.
And in the year 2016, that the arbitration award was passed.
Right.
In the year 2023, the EP was filed against the LR of the one of the JD guarantor
Right.
for attachment of salary.
Right.
So is it maintainable, sir? Because in the arbitration award, the LR has not brought on record.
If he has
Because
not,
during he's now one of the guarantor died after passing of arbitration award and before filing of EP.
see, in that case, because the LR has come into the hands, the estate of the deceased has come into the hands of the LR, he is definitely liable, because he is not personally liable, but the estate becomes liable to pay the debt, whatever has been awarded in the award.
But it is for the attachment of salary, sir.
Attachment to salary cannot be done, sir. You cannot proceed personally.
But the JDR also appointed on compassionate ground.
Even then, the salary cannot be attached.
So I have filed a petition under section 47 of CPC, how the EP is maintainable.
Questions to be determined by the executing court.
Yes.
That is 47 bracket. There's a subclass 2 has been deleted. Questions to be determined by the executing court. All questions of accord and satisfaction, and all questions that can be raised in execution can be raised in section 47.
Oh. Right, sir. Thank you.
Welcome.
Only that question.
Welcome.
Right, sir, any more questions? Sir, can a second EP be filed for arrest of for imprisonment? Sir Venkat garu, can you please repeat that?
No, not sorry.
Right, please mute yourself, sir.
Please.
Yeah, thank you. Can a second EP be filed for arrest for imprisonment in civil prison, and while the first EP of attachment and sale of immovable property is pending?
As far as this is concerned, second EP cannot be filed. In the same EP, you must ask for simultaneous execution under Order 21 to 21, please. You cannot file EPs after EPs.
BSR garu, not clear ainda.
You cannot file a second EP, sir. The same EP, you must ask for simultaneous execution under Order 21 to 21.
Right, sir. Thank you. Any more questions, sir? Anybody?
Sir, excuse me, sir. Please once again, conjugal rights details once again explain.
As far as conjugal rights are concerned, that is living under the same roof and the same bed. That is what is called conjugal rights, or the relationship between a husband and wife. Wife should not forsake the husband, and husband should not forsake the wife. Suppose the wife deserts the husband, husband can definitely say, I want my wife. Then the wife has to come and live with the husband wherever the husband stays. I'm putting the vice versa also. But in most of the cases, it's very difficult to monitor. Court cannot go every day to the house of the parties and then find out whether they're living in the same house, same roof, same bed, same so on and so forth. So restitution of conjugal rights is almost a passport for you to file a divorce petition after the expiry of 1 year, not otherwise.
Sir, I have it. Okay, धन्यवाद सर.
Right.
Sir,
In
sir, I have a doubt
yes, sir.
regarding
Please.
the money shoot.
Yes, please go ahead.
Sir, actually, after the commencement of the Hindu Section Act 2005
1955.
amendment,
Yes.
the on the sole ground of PO of application, the court can proceed. No court can proceed
Yes.
suit against the son or grandson or great grandson of the deceased father or grandfather or deceased great grandfather.
Right.
But in the same section, in it is provided that before the debt before 2005,
Yes.
it is applicable. But after 2005, it is not applicable. It was clearly mentioned in that HSA.
Yes. After this
2005 amendment.
Yes, after 2005 amendment, I request you to go through 2020 Supreme Court Vimal Chandra's case, where the Supreme Court has held that the amendment is not only prospective but also retrospective. There they say a female child, as soon as it is born, gets a vested right over the property.
Vested right in the property, but on the sole ground, PO's application, it cannot be proceeded, no, sir, against the legal rights of the deceased borrower.
The question is, the woman also gets the equal right, so her share also can be proceeded against by the decree holder because the estate has come into her hands.
Yes, yes.
She is,
But sir, in my case, the suit filed against the legal rights of the deceased borrower.
right.
That the attachment of his house.
Yes.
But only in the municipal records, his name was recorded as the owner.
Right.
But municipal records cannot confer the title.
Then in that case, you must file a claim petition under Order 21, Rule 97, please. You must file it. I'll come to that. When I come to that, I'll explain it in detail.
Okay, sir. Thank you.
Welcome.
Right, గౌజియా అడుగుతున్నారు సైమల్టేనియస్ ఎగ్జిక్యూషన్ ఏ సిచ్యువేషన్. గౌజియా గారు ఉన్నారా?
Yes, madam. Good evening, sir.
Please ask your question.
Situation simultaneous execution of
Simultaneous execution, I told you, under law you can only ask for one relief, isn't it? You can only ask, let us say, only for attachment of salary. But if you want to proceed against the movable or immovable property of the individual, simultaneously along with the attachment of salary, you have to file an application under Order 21, Rule 21, ask the court to permit you not only to proceed against the attachment of salary, but also against the attachment of mobile and sale of mobile property or immobile property as the case. Relief more than one, you ask the permission of the court in its discretion can grant you permission to proceed against both the remedies, please. That is what Order 21, Rule 21 says.
Sir, can attachment along with the arrest can be asked?
Yes, provided you file an application under Order 21, Rule 21, take the permission of the court, file an execution application. That is EA you have to file.
Yes, sir. Thank you, sir.
Welcome.
Yes. Anybody? Any more questions?
Sir, Section 7 of Family Court Act say about the property between husband and wife after the dissolve of marriage. How can it be issued and what is the solution to entertain in the family court? But we have the complaint court of civil court.
See, as far as family court is concerned, sir, I will give you the idiosyncrasies of our Hindu customs, sir. Here, once the husband and wife get married, a farm soul, as it is called, a single lady becomes a farm covert. Means she gets coupled with her husband. And you take 7 steps across the holy fire and say that, but here everything is good. You call yourself as an Ardhanarishwara also. But when the property comes, wife is different and husband is different. Wife's property cannot be proceeded for husband's death, and for husband's property cannot be proceeded for the wife's death. This is the position in India. But in England and all, it is said that you can proceed against the wife's property for the husband's death and husband's property for the wife's debts. That is the position in England. But here in India, wife is different and husband is different. You cannot proceed against each other's property in execution, please.
Yes, sir.
Okay, got it, sir.
Welcome.
But sir, my one different that is that can be challenging the civil code of law instead of approaching to the family code of law for civil dispute of land dispute type.
Say, please put your question again. Please put your question.
Instead of approaching to the family code,
Yeah.
can we approach to the civil code?
No, sir. As far as Section 9 of the Civil Procedure Code is concerned, all suits of civil nature can be filed in a civil court unless expressly barred by any enactment for the time being in force. As far as the family courts are concerned, all matters arising under the Family Courts Act cannot be agitated in a civil court because Section 9 is a bar for filing it in a civil court. Am I making myself clear to please? So once the
Yes, sir, understood.
once a special enactment is there which bars the jurisdiction of a civil court, you cannot approach a civil court. You have to go before the proper forum, please.
Okay, sir, clear doubt. Thank you.
Welcome.
గుడ్ ఈవినింగ్ ఆల్. చిన్న అనౌన్స్మెంట్ చేద్దామని నేను వచ్చాను. ఇఫ్ anyone is going to appear for JCJ tomorrow in Secunderabad Court bar room, tomorrow and day after tomorrow, 1920, right? Tomorrow and day after tomorrow, there is a class or lecture given by Santhanam sir for who are appearing for judicial examinations. So anybody is available in Hyderabad or who are residing in Hyderabad can avail this opportunity. If anybody interested, please come and attend the meeting. Tomorrow 11 o'clock at Secunderabad Court Bar Hall.
First floor.
Yes, sir. Anybody?
Madam, is it not available for online?
No, madam. It is only offline.
Because we are residing far away from Hyderabad, we are unable to attend.
Yeah, we'll try to make a record of that lecture if possible. If not possible, we can't do anything. We'll try to record the
Sorry, madam.
video, madam. Sir?
Sorry, madam. Is there any available in send in group?
Yeah,
Discussion, what
sure,
discussion
sir.
about
Once if we record the video, we'll definitely put in our group, Therma Legal group lo definitely then post chestanu. Yes, Venkat
Okay,
garu
thank you.
YouTube channel antunaru. That's what I'm saying. If anything is possible, I'll definitely try to make it possible. Yes, any more doubts or shall we wind up for today? Right, okay. Good night for all. Good night to all. I'm winding up for today. Great journey. Your stream will stop immediately and you will no longer be live. And